Anyway, just a quick overview of the topics I'll be talking about today. First and foremost is talking about what we mean by child custody and parenting plans, and then defining those, and then moving on to the factors on determining legal custody, physical custody, things that it's important to know as far as information that judges look at when we talk about legal custody and physical custody. And then we're going to talk about parenting plans, and then talking about modifications, because I know that lots of people ask questions regarding what it takes to change a divorce decree. And then also just at the very end, some resources for people seeking a divorce or changing custody agreements. So first and foremost, let's talk about what we mean by the definitions and the terms, all right? So first and foremost, child, that seems rather silly, but I find it really helpful to talk about a child as someone who's not attained the age of 18. That, again, that seems rather silly, but lots of times I get questions from folks regarding college-age children. Again, they're not really adults, but at the same time, they're also not within the code section of child custody. A child custody determination that's what a court looks at or makes a finding or a judgment or an order regarding child custody. And that's what I think it's important to think about, because again, we talk about what it means by custody. I want to skip down to joint custody or joint legal custody, because I find that lots of people get those two terms confused. And I always describe it to my own clients as follows. Legal custody means that you have all those rights and obligations that parents do. The right to get a child medical attention, the right to get their school records, the right to have a say in what the law deems the major decisions about a child, where they're living, where they're going to school, medical decisions, extracurricular activities. Again, kind of the big decisions about what a child, like in a child's life. In legal custody is almost always joint. I have been practicing law 23 years, and exclusively for the last 20 years have been doing family law. And I can count on one hand the number of cases I've had where legal custody was not joint. And when we say we have joint legal custody, that means that you have each parent has equal decision-making power regarding the children, okay? That the parties are to discuss and attempt to agree on the major decisions about their children, okay? And again, I was kind of categorized it in 4 places: medical, extracurricular activities, education, religion, okay? Let's talk about physical custody. And physical custody is custody and how we all think about it, where the children or the child is living on a day-to-day basis. And what does the schedule look like of physical care between the parties? And physical custody can be anything from, I'm going to be stereotypical, mom has physical custody, or we call primary physical custody, and dad has certain set times that he's going to see the child. We call that a lot of times visitation or parenting time. To dad has primary physical care, mom sees the children at set times, but the children live primarily with dad. To shared physical or joint physical care. And joint physical care means that the children are with each parent roughly 50% of the time. And so they're moving back and forth between homes on a fairly 50-50 basis, okay? So again, when we talk about physical custody, it's where the child is, laying their heads. Is it that they live primarily with one parent and see the other parent, or do we have shared physical, or sometimes we call it joint physical care, when each parent has roughly 50% of the time with the kids. And again, I always want to start out with my own clients defining that, because a lot of times I have people who come in, and they'll say, well, I want joint custody. Well, what does that mean to you? Or they come back and say, my husband's filed for divorce. He wants joint custody. Well, what does that mean? And when I dig a little deeper, sometimes, that what they have in their head and what legally is the definition are two different things. When we talk about parenting plans, what a parenting plan is that is a written plan for parenting children. And that seems rather silly, but lots of times we need to have some definition about how things will be handled, such as how will medical appointments be scheduled for the children? Will one parent schedule it? Will both parents attend? Will the parent who schedules it take the children? So what does that look like? How are the transitions for the children handled? Will the pickup and drop off be at school, or will they be at one parent's house? So a parenting plan can be broad, and I've seen some parenting plans that are really, really defined and very down to the detail. So again, we specify about how the children are going to be parented. And then I just talked about physical custody. Visitation rights, we also call that a lot of times parenting time. And again, if one parent is going to have primary physical care of the children, meaning the children are going to live with that parent most of the time, in Iowa, we have a statute that says that other parent has rights to see the children. And in fact, we operate from the premise to start with that children need both parents. What that looks like is sometimes up for discussion, but both parents are going to have contact with the children, and the children are going to have contact with both parents. We operate from the premise that parents are in the best position to determine child custody, or what I would call physical custody of the children, and again, those legal custody decisions. We think that parents are best to determine those things. But we also say when you go through a divorce, or when you no longer are with the father or the mother of your children, then the court can take action in making those determinations. I'm talking a lot about divorce, but these premises are applicable if you've never been married and have a child together. The court looks at these code sections in the same manner. So I guess I want to preface my information that this doesn't just deal with divorce cases, but what we call also paternity cases, which means the parents were never married but have a child together. So let's talk about how we determine legal custody, okay? And again, this is kind of going over what I talked about, is that it's the right to make decisions regarding the child, the right to access information, and it does not necessarily deal with physical custody of children. And when we talk about right to access information, that can include things like school records. It can include therapy records. It can include medical records. So any information that would be regarding a child, a legal parent can access. And under the Iowa Code, in a divorce or in a paternity case, that a divorce decree or paternity order is going to specify that both parents have equal rights to access that information. So if a parent, a lot of times I get questions about, sometimes I get questions from schools that they'll contact me and say, hey, I have this divorce decree. It says they have joint legal custody, and but mom says that dad can't have copies of the child's grades. Or I get a question that, dad says mom's not supposed to be at the school. And my response to that is if they have joint legal custody, again, they have the right to access that information. Joint legal custody also is to mean a shared decision-making process. And it's supposed to also mean collaboration for the child. In every divorce decree that I draft, I once had somebody say, it's a little like you're lecturing me, Angie, about what I'm supposed to do post-divorce. Well, yes, this is, again, a reminder as you are to discuss and agree on, if you can, these major decisions about your children. So when I have clients who call and say, well, I want to change my child's school, one of the first things I say is, well, what does mom say? What does dad say? Because that's a joint legal custody decision. If you're going to change physicians, again, joint legal custody decision. If you're going to have tubes put in your children's ears, that's a joint legal custody decision. Okay. And again, if there are questions, I welcome those as we're going along here. Yeah.
So at what age, and you're probably going to say 18, at what age does a child get to make the decision for themselves whether or not they are comfortable with the other parent getting access to their medical or records? When does the child get a voice?
Regarding access to information, you're right, my answer is 18. So that under the age of 18, a child's desires or wishes regarding access to information to either parent is not necessarily to be considered. Now, I want to preface that by saying I have had issues regarding therapy records where the therapist has taken the position that they are not going to disclose to either mom or dad what the child has talked about in therapy. But again, that's an issue between the two of them, between a therapist and a patient. That's the therapist-patient relationship, not necessarily access to school, access to medical records. And again, that was the therapist that took that position, not the child. So, does that answer your question? Okay, all right. So a lot of times also, again, I preface this by saying that in the 20 years I've been doing family law exclusively, I can count on one hand the number of times I've had legal custody awarded solely to one parent. And in those circumstances, in one case, dad had a significant alcohol issue. And when I say significant alcohol issue, I'm talking about like he came to serve his 5th OWI and he was intoxicated. I had 2 cases where dad was in prison. I had one case where it was my client who had some significant mental health issues. And when I say significant mental health issues, the voices were telling him certain things. And then in one case I had, mom had a significant alcohol issue. So again, it comes in limited circumstances. But Iowa Code Chapter 59841 is the controlling statute regarding joint or legal custody. Typically, the court is going to award legal custody to be joint. Now, the one thing that the court does look at in deciding legal custody is there domestic violence between the parties, between the parents. And, typically, it's not just domestic violence between the parents, but how has the child been affected by that domestic violence? So that there are grounds in which to award sole legal custody. But again, those happen in very, very few circumstances.
Angie, we have a question. Yeah. In the state of Iowa, does a child under 18 have input into which parent they want to live with?
Sure, and that, I think if we could just table that question just for a second, because I want to finish my talk about legal custody, and then I'll go on to physical care, because that question really deals with can a child under the age of 18 decide which parent to live with? I mean, what's their voice? So when we talk about, again, joint legal custody, either parent can, most parents ask for joint legal custody. If it is denied, the court has to be specific as to why it's unreasonable to allow joint legal custody and why it's not in the best interest of the children. So we really, again, it's a really high burden to be awarded sole legal custody or have, a case where legal custody is not joint. Here's, I guess, some samples of joint legal custody language. Both parents shall have legal access to information concerning the children, including but not limited to medical, educational and religious records. Both parties shall participate equally in the rights and responsibilities. They'll consult and agree with each other regarding respect to education, religious training, extracurricular activities, and major matters relating to the children. So I put in some, I guess, what I would see as typical language regarding joint legal custody so that people have an understanding as to what a divorce decree or what a paternity order would say. I have people all the time that say, why do I have to put that in there? I always respond to, I think it's a good reminder as to you had these children together and therefore you need to try to parent them together as best you can. Now that is not easy, but it's a good reminder of the things that you need to be consulting each other about. The one thing also too is that legal custody does not automatically mean an award of physical custody. They are separate and distinct things. And, the Iowa Code Section 59841, those factors are to be evaluated for both types of custody. So, and I want to, I guess, read that code or read the provisions of that code section at 59841. And so the statutory factors are, whether each parent would be a suitable custodian for the child, whether the psychological and emotional needs and development of the child will suffer due to the lack of active contact with the intention from both parents, whether the parents can communicate with each other regarding the child's needs, whether both parents have actively cared for the child before and since the separation, whether each parent can support the other parent's relationship with the child, whether custody arrangement is in accord with the child's wishes, the geographic proximity of the parents, whether the parents agree or oppose, whether the safety of the child or the other parent will be jeopardized, and whether there's a history of domestic abuse. Okay. I've noted in here a case, what I think is kind of what I would call a seminal case in the state of Iowa regarding shared physical custody, and that's In re the Marriage of Hansen. And In re the Marriage of Hansen really discussed the factors that a court is to look at regarding joint physical or shared physical care. And again, in Hansen, one party argued, well, I have joint legal custody, I automatically have shared physical or joint physical care. And the Iowa Supreme Court said, no, that's not how this works. Is that while the joint legal custody was being ordered, they did not feel like joint physical or shared physical care was appropriate in the case before. One of the things they talked about that in Hansen also really talked about when we have shared physical care, what are we really looking for? And that is, a sharing of childcare responsibilities before the divorce happens or before the divorce gets filed, communication and respect between the parties, as well as the best interests of the children. So the court in Hansen, in Ray, the Marriage of Hansen, really said, these are the things we're going to look at in a shared physical care arrangement. Okay, so let's kind of go to what everyone really wants to talk about, and that is, how do we determine physical custody? Okay. And again, when we talk about primary physical care, that means that physical care is awarded to one party, the child lives primarily, that they have a right of supervision for that child on most days. And that means that the child's really going to have primarily one home. What we see typically in arrangements like that are, every other weekend from a Friday to a Sunday and an evening a week that they see the other parent. But the other times of the week, they are living primarily with one parent. Joint physical custody, again, it's shared physical care and split time. A lot of times we have much more detailed parenting plans when we have shared physical care, because that does require people to communicate more about their children than if the children are with one parent primarily. And it does mean that there's more responsibility for both parents. It isn't just that they are, when we talk about details of a parent, think about your own children and how much, I think about sometimes the details that are required for my own children about what time do they need to be at school today? Do they have everything? Is it green shirt day and we're all wearing green shirts? Do they have the $20 for their field trip that they're supposed to have? Where are they after school? What time is their soccer practice? Do they have their band instrument? And so again, in shared physical care arrangements, we a lot of times see more detailed parenting plans because people need to have those conversations about how things are going to be handled between their kids. So what goes into a determination of physical custody during a divorce or during paternity action? First, and there are lots of factors that go into this. And what I point out to my own clients is there is not one factor that drives any of this. They're all supposed to be kind of looked at equally now. So that's really difficult to do. The other thing is that a determination of physical custody is, if you can't agree, is decided by a judge. And what I say to people all the time is our judges in Iowa are smart and they're very hardworking people, and they try to do their best every case, but they will know very little about you and your children, even after trial. And so they're making determinations about what should happen to your children on a day-to-day basis, knowing very little, but that's the way our system is set up. So the factors that the court looks at is, number one, a history shown by the parent. So we're really going to look at, has there been a division of duties where there's one party that's really doing 90% of the work and 10% to the other parent? Or is this something that's really been a 50-50% effort between both parents? A lot of times I say to my clients who say, well, I want shared physical care. One of the questions I ask them is, have you taken your children to the doctor? Can you tell me who your child's doctor is? Because I want to know, have you really been an integral part of their lives? And lots of things go into parenting, don't get me wrong. But that, again, we're looking at what's the history shown by the parent. We're also looking at a parent's mental health or maturity level. I say to my clients who are going to have primary physical care, it is your responsibility to ensure as best you can that relationship between the child and the other parent. And so you need to be thinking about them first and foremost on everything. That's very difficult when you're going through a divorce and beyond, but to be thinking about mental health and maturity level and demonstrating that. We also look at stability and continuity. Is one parent going to stay in the house? Is that one of those issues where the children are really tied to that neighborhood? They have all sorts of family, or they have friends and family that are near it. Are they going to have to change schools? We look at trying to keep his kids as stable and as in the continuous care as they have felt during when their parents have been married or together. We also look at what's in the long-term best interest of the child. The primary concern is always to determine what's in the best interest of the child. That is a very gray area, very gray area. And what's in the best interest of a child, I may have a different view about what's in the best interest of my child than somebody else may think that is in the best interest of their child. And so again, if you leave it up to a judge to make the determination, it can be very, again, it's a gray area. Courts operate from the fact that both parents, again, need to see the children, that the children need to have contact with both parents, and we are to continue maximum continuous contact between both parents. How that looks like or what that looks like, is up to the court to decide if the parents can't determine that or make that decision. Visitation rights. Visitation rights, it can be anything from, again, non-supervised, it can be supervised or professionally supervised. What I say to people all the time is to have professional supervision ordered. That is a really high burden. That is typically seen in cases where a child has been subject to abuse or neglect by one parent, and that the Department of Human Services has gotten involved and made recommendations regarding that supervision. Sometimes we see, families supervise, and a lot of times I see this when, for example, a parent has not had much contact with the child for a period of time. And so for all of a sudden that child to go for a whole weekend with mom or dad may be too much, but that maybe that supervision happens. We go to the mall, we go to play basketball, we do something where it's kind of semi-supervised. And then what is we see most of the time is non-supervised visitation, meaning that the children are going to go with each parent and spend time at their respective homes. And we operate from the premise that parents are going to make decisions in their kids' best interest, and that parents are going to be looking out for the best interests of the children and making decisions that good parents do. And again, good parents are the eye of the beholder. I say this to my own clients. My husband and I operated from that our kids didn't have TVs in their bedrooms. I know lots of families who allow their kids to have TVs in their bedrooms. That's not right, that's not wrong, that's just a parenting decision. And so again, we operate from the fact that most parents are going to make those parenting decisions. We also look at kind of, again, quality of contacts over quantity. That's what I say to my own clients. Think about how you can be with your children and exercise that time as best you can, and to not worry about, well, she has 5 more hours or he will have 4 more hours than I do over Christmas. That really kind of gets you nowhere. And quite frankly, I think people miss out on time with their kids that they really should be spending with them. I mentioned this really briefly. Physical custody determined for a child born out of wedlock. It's the same thing. We look at the factors for 598-41. I just realized that I glossed over the question we had about a child's wishes. I get that question all the time. And I want to state, first of all, that there is the biggest urban legend ever that children who are 14 get to decide where they live. That's not true. There's no statute that says that at all, ever in the state of, not in the Iowa code at all. Now, a child's wishes can be factored into the determination about physical custody. But we look at, is that child of sufficient age, maturity, and intelligence to make that decision? I say to my clients all the time that I know lots of 12-year-olds that are really mature who can make that, who can voice that and have good reason to voice it. I know lots of 17-year-olds that don't have that sufficient maturity and intelligence to do that they're mad at their mom, they're mad at dad for, they're not paying for my car, they kicked me off the Xbox kind of thing. So again, we're looking at what a child, again, age, intelligence, can they make that decision and voice that? But as I say to clients all the time, that as children do get older, a judge is more likely to listen to what they would like. At the same time, that does not mean a child's wishes is not the factor. It is simply a factor to look at. So I glossed over that question. Yeah, so anyway, opinions of children are not entirely controlling. They're relevant and can't be ignored. Yeah.
What is the proper avenue for a child to have a voice during any proceedings, whether it be the original decree or a modification?
That's a great question. And unfortunately, it depends on where you are in the state of Iowa. If you are in a larger metropolitan area like Des Moines or in Cedar Rapids, there are more resources for children than if you live in rural Iowa, unfortunately. I think that's a disparity. So let's talk a little bit about options to make that child's voice known. First and foremost, there is what you could have an attorney appointed for your children or child. And an attorney is to represent their interest. And they can call witnesses, they can enter exhibits, they can, if they'd like to, call the child to testify under the appropriate circumstances. And if there is appropriate circumstances, they can step in and do that. For example, I had a custody modification where I represented one parent. The children were represented. One of the children, who was a 13-year-old girl, is, for those of you who have teenage daughters, you understand that they are very opinionated and they want everyone to know that opinion. I have teenage daughters, so I totally get that. But this child really wanted to come in and tell the judge her opinion about things. So the child's attorney was able to convince both parents and both lawyers to allow that child to testify in chambers with the judge, just with the court reporter, the judge, and the child, and her lawyer and the child's lawyer. That mom and dad and their lawyers were not going to be present. Okay, that was by agreement. We did that. But that the lawyer for the child can advocate for their client, the child, to come in and be a part of that proceeding. And again, you have to be very careful about that. Again, in that circumstance, I said to my client, do you really want to be sitting in the courtroom when your daughter comes walking through? I personally don't think that's a good idea for you, but that's, you have to make that decision. So, and again, first and foremost, attorney for the child. The other avenue that we have lots of times is what we call the child and family reporter. We used to call that a guardian ad litem. The terminology has changed about a year ago. And what a child and family reporter is to do an investigation and make a recommendation. That child and family reporter can be a lawyer. They don't have to be, but they can be a lawyer. And they would talk to the child, they would talk to the parents, they would talk to school, they would talk to the therapist if there's a therapist involved, they would talk to other people or review documents. And again, their job is to make a recommendation to the court as to what they think is in the child's best interest. And so there's a little bit of a legal difference between those first two. A lawyer for the child is to represent what the child's desires are. Okay, so a lot of times we see an attorney for the child appointed when you've got teenage kids or older children. Or a child and family reporter is to be appointed to represent what's in the child's best interest. A lot of times we see that when kids are maybe school age, they're 6, 7, 8, they're able to articulate some things, but really, voicing what they would like to have happen, they're probably not of sufficient maturity and intelligence to do that. And then the final option is a custody evaluation, where typically a licensed social worker or a licensed psychologist trained to do custody evaluations is done. And the difference really between a child and family reporter and a custody evaluator is typically custody evaluations include some sort of psychological or mental health examination. So again, that's why typically the social worker or the licensed psychologist does that, because there's a little bit more of a mental health component to that. And again, that custody evaluator is to make a recommendation to the court as to what should happen. And again, I remind people all the time, even if with a custody evaluation or a child and family reporter, their job is to make a recommendation. There's not an automatic, there's not a statute that says, well, if someone makes that recommendation, a judge has got to go along with it. Again, that's just a factor the court's going to look at. And it's the same, type of, again, that's not a more important factor than what a child wants, or more important factor based on the historic caregiving of the child or children. So does that answer your question?
I think the remaining question is for the situations where there's not the same financial resources for, like, when does a child get this equal say, even if there's not the money to pay the thousands of dollars for these attorneys and such?
And you have touched on an issue that is really, quite frankly, kind of near and true to my heart. But there is no right to counsel in a divorce case for children. There's no right to counsel for parents in a divorce case, unfortunately. We do not have a system that pays, if you are criminally charged with something, you have a right to counsel if you can't afford it, and the state will pay for it. You do not have that same right to counsel in a divorce case, even though I would argue that it's just as important. And so there are some agencies in the state of Iowa. Again, this is a disparity as to where you live. If you live in Des Moines or in Cedar Rapids, there's an organization that represents children called Kids First. And they do things on a sliding fee scale. They do things for a limit for, they get grants and donations to do things on so that people are not paying, a lot of money for those services. But that's where that's unfortunately, unless you are in Polk County, Lynn County, or Johnson County, there's not any other organization that I'm aware of that does that. And again, if the court doesn't have the money to appoint lawyers to represent children, or child and family reporters, or custody evaluators. So there is a disparity in between, again, if you have resources versus if you don't have resources. And those are the things that really keep me up at night and really trouble me about the system, because I do think it creates a two-tiered system. So. Child custody determinations are deemed to be final only if if everyone has had the opportunity to be heard, custody, physical custody, legal custody, parenting time, visitation is all subject to modification later on. Let's talk about temporary physical custody. As you can imagine, when you and your spouse or you and your partner are splitting up and things are, acrimonious, then at times judges need to step in and make determinations regarding physical custody and parenting time of children. And the court has the authority to do that. Now, what I remind people all the time of is if you are married and you're living in the house together, a judge does not have the authority to order either one of you to get out of the home unless there's violence. So typically, lots of times, we have people who remain living together during the pendency of a divorce. That is not always an easy thing to do, and most times it's not at all easy. There's a reason you're getting a divorce. But, again, you both are entitled to live in the home together, and for lots of folks, it's, economics mandate that, remaining in the home is the best economical decision. Those temporary physical custody determinations are not final. They can be appealed to the Iowa Court of Appeals or Iowa Supreme Court as an interim appeal. They are not typically done that way. I mean, typically because an appeal takes longer than most of the time the original divorce takes, but they could be appealed. But again, they're not deemed as final judgments. Again, this is just if one party is going to have primary physical care, that other parent is going to be afforded time with the children. The governing concern is in the best interest of the child. Liberal visitation is really to be ordered. Again, what we mean by liberal is in the eye of the beholder. If you can't agree on it, what is liberal to one judge may be different than another judge. I once had one judge say to me when I don't always think judges are, I say to people all the time, you ask 10 different judges, you'll get 10 different answers. And on 10 different days, you'll get that. I mean, you can ask the same judge the next day and you'll get a different answer. I once had a judge say, well, I don't think, a first grader should be spending the night, a school night with the other parent. It was like, okay. And then I had a case in front of this same judge like 2 years later. And sure enough, what did he do? He awarded parenting time to the other parent during the school week overnight. So again, in that case, he felt like that was appropriate. And in one case 2 years before, he didn't think it was appropriate. So I just point that out to people because so many times they come to me and say, here are all the facts I have. I'm going to get primary physical care, right? Or I'm going to get joint physical care, right? It's like, I don't know. So it sometimes it's very difficult. Visitation or parenting time can also be modified if it needs to be. I guess I want to talk a little bit about the similarities between legal custody and physical custody or physical care. They both use similar factors in their determinations. Similar situations can arise. Both of them have the primary focus of doing what's in the best interest of the child. And both factors that are outlined in the Iowa Code can result in the court's decision of sole legal custody, joint legal custody, joint physical care, primary physical care to one party. Again, the differences are one involves decision-making, the other one involves, I say to people all the time, where does Bobby sleep at night? Where does Susie sleep at night? Who decides whether, they eat peas or carrots for dinner? Whether they decide whether or not they can go to the neighbor's house and play after school. Those are the things when we talk about physical care. I want to talk a little bit about the importance of parenting plans and again, what we And what we talk about with, when we talk about parenting plans, again, I think they're important if the parents are to share joint physical custody of a child. And I think they're important because it forces the parents to sit down and talk about those decisions that, while they're not huge, they trip parents up. Things like, at what age should our children get a cell phone? At what age should they get a school permit to drive a car? At what age should they date? All of those decisions that really, again, if parents are not on the same page about, really lend themselves to issues, I think, with kids. And I use this example all the time. I remember when my oldest child was about 4, and we were sitting at the kitchen table, and she looked at me and she said, well, can I go to the neighbor's house and play right now? And I said, no, because you need to take a bath. And she turned to her dad, who was sitting right there, and said, can I go to the neighbors and play? And so I use that example is that if kids think that you're not on the same page about stuff, they will use that to their advantage. And I think all kids are great, but they're kids. And if they think they can use something to their advantage, they are human and they're going to do it. I also share this example all the time because I say this to my clients who have small children and can't decide, do they play soccer or football? And I say, you need to get on the same page when those kids are 4, 5, and 6, because when they get to be 13, 14, and 15, if you're not on the same page, it's trouble. Because I once had a client that her ex-husband traveled a lot. And she said to him, I just want to know when you're out of town. I don't care where you're gone, but I want to know if you're out of town because Billy likes to go over to your house and play basketball because that's where the basketball hoop is. And Dad was like, absolutely not. You are not going to control me. You're not going to know that information. That is an invasion of my privacy. And so, my client was like, oh, what am I going to do? I'm like, well, there's nothing you can do. Well, fast forward about 6 months, Billy went, Mom got a call from the police department in a suburb here and said, oh, we found Billy at his dad's house along with like 6 of his friends. And they had cracked open some beers. So again, going back to that, if Billy knew that those parents were not on the same page, and he's going to use that to his advantage because he knew that Dad was never going to tell Mom if he was out of town. So anyway, again, I think parenting plans are helpful because it forces people to have the conversation and attempt to talk about how are we going to handle this. And again, it's, we try to do it kind of with the best interest of the child in mind. Parenting plan provisions, examples. So things like, how are the children going to be transferred back and forth between the parents' homes? Do we have a situation when one parent lives, or the parents live 40 miles or 40 minutes away from each other, and we're going to meet? Or is all the drop off and pickup going to happen at school? Well, what if we don't have school? Is it that, one parent is going to come get the children and the other parent's going to pick them up? How are we going to transport them? The other issue that happens is, when the kid turns 16, is Susie going to drive back and forth between her parents' house? Is that okay? How are we going to enroll and pay for the children's activities? Who's going to take the lead when we talk about soccer sign up? Who's going to pay for it? And again, this seems like minutia, but this is the stuff that people pay lots of money to lawyers to argue about, which is, again, it's how I make my living. But if I never had a case where I had to argue about, how we were going to pay for select soccer, it would be too soon. Let me just tell you. How we're going to handle the rules, driving, cell phones, dating. How we're going to handle disagreement, because people are going to disagree. One party thinks that, Susie ought to be able to quit, the traveling softball team she's been on for the last 3 years. and another parent may disagree about that. And so how are we going to handle those disagreements? Typically we have, things like mediation. And for those of you who don't know what mediation is, that's when a neutral third party works with the parents to get them, or attempt to get them to agree about the situation. And again, they don't make any decisions, but they're there to be, for lack of a better word, a discussion leader, to offer suggestions and to get parties on the same page if we can. A lot of times we enroll therapists to help people have better communication and how to be a better co-parents. Lots of times I look at people's emails between each other and I say, wow, when you start with the shouty caps, perhaps that turns off people. So let's think about how we should communicate that. Or if you're asking one question, did you really need to have 3 pages? I mean, to think about how they communicate and to be short and to the point and really focus on the information that either need to transfer or that the answer that they need to get. And lots of times, people get divorced because they're poor communicators. And unfortunately, the legal process isn't necessarily the best about trying to build those skills for people, even though they really should be. So again, co-parenting counseling can help people try to improve their communication. And if they really need some really big assistance, we have what we call parenting coordination. And parenting coordination is a alternative dispute resolution process. The parties agree about a parenting coordinator. They have that parenting coordinator appointed. There's an order that says, here are all the duties, this parenting coordinator, this is how it's going to get paid, this is what we're going to do. And a parenting coordinator, in my experience, most of the time will attempt to get people to agree on issues if they can, but if they can't, they're empowered to make the decision. And so, for example, I've had clients who could not agree about their children's school, where their child was going to go to school. And so we sent them to parenting coordination, and they agreed that the parenting coordinator would make the decision if they couldn't agree on it. What I say to people all the time is that parenting coordination, they're going to make decisions that judges really do not want to make and unfortunately don't have time to make. A judge doesn't have the time to decide, does Bobby play basketball or baseball? Doesn't have time to decide whether does Susie stay in private school or go to public school. So we turn to parenting coordination to really assist people to make those decisions.
Say, Anjie,
Yeah.
Can we ask, this is from one of the libraries, would that be would a parenting plan be helpful if one parent consistently tries to deny the other parent the opportunity to take the child to the doctor? Can any county, can you request that you have the opportunity for a parenting plan, whether it's after a custody decision has been made or?
And that would involve, if you're in an original divorce situation, you're in the middle of a divorce, again, having a parenting plan done before you get divorce is final is helpful. If you're in a situation where your divorce decree has already been entered and those are problems that arise, you can ask for a modification. And I'm going to talk about modification here in just a second. And a modification would allow you to, again, have that parenting plan, to have that conversation about how are we going to handle medical appointments for the child? Because at the end of the day, everyone just wants their child to be well and healthy. And children are well and healthy, the less conflict there is between the parents. And so if there's anything that can do to help alleviate that conflict, then I think, it's important. All right, child custody modifications. So child custody modifications happen when, again, a divorce decree or paternity order has already been put in place. And physical custody can always be modified. So can parenting time or visitation. It also can be. There is a different burden for each. And so I always want to tell people this. only certain circumstances, and judges typically have reasonable discretion that they can employ about whether or not this rises to something that warrants a change. So in Iowa, in order to modify physical custody, 3 things need to happen. 1, there needs to be a substantial change in circumstances. Okay, and when I say substantial change in circumstances, that's a high burden, number 1, because, you know, he got a new girlfriend, not a substantial change. She quit her job, she got fired from her job, not a substantial change. Typically, you know, things like, you know, somebody went on active military duty, or there is, you know, drastic changes in living situations. Again, not, you know, not we moved across town and my kids are sharing a bedroom now. I mean, you know, that's just typically not enough to modify custody. The second thing, so substantial change in circumstances, all right? And not every change is going to be substantial enough. Number 2 is that the modification request would, that you have proven you can more effectively parent than the other parent. So, you know, mom has primary physical care. I'm going to be stereotypical here for a second, sorry. Mom has primary physical care. Dad comes in and says, I don't like mom's boyfriend. You know, again, is that a substantial change in circumstances? Probably not. I have to prove that I can more effectively parent these children than mom can. And finally, it has to be in the best interest of the children. So those 3 factors have to occur, and all 3 factors have to be shown. The reason we do that is that we don't want kids bouncing back and forth. We want physical custody to be set and for it to be remaining. And so again, it has to be a substantial change in circumstances. How often is child custody modified? You know, that I don't know, but it again typically happens in very limited circumstances. Yes.
You lost me. I have number 1, substantial change in circumstances, and number 2, overarching concern is to look at what would be in the best interest of the child. What's number 3?
And number 3 is that arrangement or that parent can more effectively parent the child.
Thank you.
Sure.
Angie, can we jump in with a question from a library?
Yeah.
So it sounds like if one parent has moved out of state and is not really showing that they're interested in custody, that might be an opportunity for modification, but it doesn't necessarily mean that the parent that is still in the same location would get sole custody. We'd have to look at those other 2 factors.
So again, let's talk about, we're talking about physical custody or physical care. All right. If one parent has moved, if one parent has moved out of state, that can warrant a change in physical custody, a modification of physical custody. The parent who moves out of state, though, is still entitled to parenting time or contact with that child, because that's really important. One of the things that they've done lots of research about, and I don't know how many people have heard of adverse childhood experiences. One of the biggest factors in adverse childhood experiences is the loss of a parent. And when I say the loss of a parent, it isn't necessarily just my parent died. It also can be I no longer see a parent, or I no longer have contact with a parent. And so we try really hard to ensure that kids have contact with both parents. And so even again, that parent moves out of state, they're still entitled to contact. And so one parent would have primary physical care of the child, but that other parent is going to have visitation or parenting time with that child.
And if they don't want it, then they just don't use that opportunity.
Correct. And it always breaks my heart a little bit, but sometimes that is an issue that our parents make that decision that they don't want to have contact with that child. And you can't hold a parent in contempt for not exercising their time. you can be found in contempt if you don't allow the exercise of the time. But if one parent says, I'm not going to see the child, then you can't be held in contempt for it.
And it sounds like, will you touch on termination of parental rights if they choose to they don't want anything to do with this child? Is that something you see?
I have seen that. Termination of parental rights is typically very limited circumstances. Usually termination of parental rights happens because there's been abuse or neglect of the child. I have had some cases where parents say, well, I just want to terminate my parental rights. And under the Iowa Code, judges have the authority to say no. And I have had judges say, no, I'm not going to agree to terminate this parent's rights because they have an obligation to parent their child or to financially support their child. And so I'm not going to accept that. Usually they will do that unless there's a step parent willing to adopt, in my experience. Okay, I just, I had some cases in here that if you wanted to Google and get on and look at kind of, again, factors I get so many questions about modification. Again, it's a little like an initial custody determination where somebody comes in and says, here are all the facts. Can I modify custody? I put in some cases that you could Google and look at that talked about, here are the facts where we talk about custody modifications were successful. So,
oh, time out. One more thing on the modifications.
Yes.
Okay, so even if a person petitions to modify, and in that petition, just because they initiate the petition, that whole process has to start over, or is it ever an appropriate response for the judge to say, there are not enough grounds in this petition to modify, so end game?
That's a great question. In a modification, it is the same process that original divorce goes through. So again, somebody files a petition, the other party files an answer. There is, an information exchange or what we call discovery. There's the whole process. And, in my experience, prior to a trial date, a judge is not going to come in and say there's not enough to modify. They just don't do that. First of all, because typically there are all sorts of facts that go into, I think I just did something to change that. Sorry, this is why they don't let me hold the remote up here. Okay, there we go. I won't touch anything more. And so, typically everything, every fact is an issue. And so they're not going to do that. They're not going to make a determination about whether there is or isn't enough to modify prior to actually having a full trial about the facts. And that's just, again, that's the way our system is set up. So, yeah.
We have another question from one of the libraries. Does a biological father have to be on a birth certificate in order to have financial responsibility for a child? And if they do, how do you go through that process?
Sure. So that's what we call the paternity process. Typically, if you're a father who's not on the birth certificate, you have the right to petition the court to have you put on the birth certificate, as well as establish your rights, custody rights, legal custody rights, physical custody rights, parenting time, as well as establish your visitation and your child support obligation. So there is a process by which, if you're not listed on the birth certificate, you could be.
And the mother could go through a similar process?
Correct. I didn't touch anything, Christy, I promise. So there was a question that was submitted ahead of time about if a parent moves out of the family home prior to filing for divorce Is there a way to ensure the child spends at least part of the week with the parent who moved out of the family home? And again, that's that temporary determination of physical custody and parenting time that would be entered. And, that would require you to go ahead, you have to file for divorce, because the court doesn't have the authority to do that unless you had filed for divorce. And so once a divorce gets filed, then the court does have the authority to make determinations on a temporary basis regarding the schedule with the children. There was another question in here that my divorce decree was ignored when a case was opened in juvenile court. The DHS worker now has given my abusive ex-husband visits and I don't have any. What can I do? And one of the things I want to point out to people is that when juvenile court gets involved, then juvenile court trumps district court or family court. Juvenile court has exclusive jurisdiction if the Department of Human Services has gotten involved and opened a child in need of assistance case, and juvenile court trumps. And even if you have a divorce decree that says X, the juvenile court has the authority to say, well, we're gonna say Y right now, because that's what we think is in the best interest of the children. So, do we have another question, Virginia? Okay, all right, great. Well, I did have in here, maybe. I did have some resources listed for parents seeking a divorce or to, making sure that their children's voices were heard, and those are listed in the materials. Again, I point to the Kids First organization, and that's kidsfirstiowa.org. The Iowa Judicial Branch, I think, has some terrific materials about just general overview about child custody. Again, legal custody, physical care. Because I say all the time, this is a lot of information, and I feel like I just went and just, threw up information at you. So as you go back through it and have questions, going back to the judicial branch, that website has some really good information about that. And about also just, representing yourself, but also, with, having children, have their voices heard. So.
We do have a question from one of the libraries, and we welcome during these last 15 minutes, if there are any questions out there, that you go ahead and submit those if you'd like to. Anjie, can you tell us, is there a relationship between child custody and child support decisions and what that's like? That's
a really good question. In a nutshell, yes. So child support in Iowa is we are required by federal law to follow the child support guidelines. And the child support guidelines are set out. They review those and redo those every 5 years or so. And we are by law required to follow those child support guidelines in every divorce. I have lots of clients who come to me and say, well, we've agreed he'll pay me $200. And I say, well, that might be a great idea, but a judge is not going to approve that divorce unless we can demonstrate to him or her, that the child support guidelines have been followed. And if they haven't been followed, why they haven't been followed. And there's got to be some good reason that they're not followed. So in Iowa, we use parties' incomes to determine child support. If one parent has primary physical custody, the other parent is going to pay child support. And depending on the amount of time they have, they can see a reduction in that child support. If you have more than 127 overnights in a year, you are to receive a credit, what we call an extraordinary visitation credit against your child support. And there's, different levels of that depending on how much time the non-custodial parent has. If you have shared physical care, you can still be paid, one parent can still be ordered to pay child support. In a shared physical care arrangement, we use what we call the offset method, meaning we calculate what mom would pay to dad if dad had the children full time, and then we would calculate what dad would pay to mom if mom had the children full time, and do an offset. And so even in a shared physical care arrangement, lots of times I have people who say, well, she thinks that she's not going to have to pay child support if we have shared physical care. Well, that may be if your incomes are fairly similar, but that might not always be even in a shared physical care arrangement. On top of that, the Iowa law says that parents can be ordered to share expenses for the children in a shared physical care arrangement. So again, the child support may be less, but you've been ordered to pay for half of extracurricular activities, for school fees, for medical expenses, for as kids get older, for prom dresses, for cars, for car insurance, those types of things. So unfortunately, physical custody and child support are somewhat tied.
So Anjie, this is another question from one of the libraries. It sounds like really the issue of financial responsibility relates to the custody determination rather than whether the parents are married.
Correct.
And there would be a custody determination regardless of whether the parents are married.
Correct. So if the parents were never married but have a child together, that both parents are obligated to support the child. And so again, we're required to follow, in those cases where parents were never married, the child support guidelines. They're just as applicable to those actions as they are to divorces. So.
Okay, sorry, I have a lot of questions. So the next one is really going to relate back to the child support guidelines.
Okay.
If one person is pro se and the other person has an attorney, for as far as when that person's attorney files the child support guidelines, what records must be presented to prove the income that the party is basing their child support guidelines with?
So again, under the Iowa Rules of Civil Procedure, there are certain documents that have to be produced between parties. Tax returns, I'm going by my memory here, so I apologize if I'm not 100%. Full and complete tax returns, I think that says the last 3 years. Pay stubs, again, that's required by the Rules of Civil Procedure that those documents have to be produced to the other party. The other thing is, both parties have a right to what we call discovery in any action, including family law actions. And discovery includes interrogatories, which is a fancy term to say you got to answer questions under oath about these certain topics, or request for production of documents, which is just like it sounds. You got to produce to me certain documents. I want your tax returns for the last 5 years, not just the last 3 years. I want your pay stubs for the last year rather than the last 2 months. So you can ask for additional things that are that are outlined by the Rules of Civil Procedure. So, yeah. And also with child support guidelines, you have to certify. I mean, as a lawyer, I'm certifying under, as my professional responsibility that I'm calculating this to the best of my knowledge. My client, to me, it's a sworn statement that my client is kind of saying, I swear that this is true and accurate information. So, I mean, those are, court documents.
Thank you, Anjie. Apologies to the libraries out there and to our participants here. We're having a little bit of a technical issue and we've alerted our tech team. I don't know if it will resolve before we close this evening, but thank you for bearing with us in that regard. We have a question, Anjie, about the potential effects of a drug charge that one parent may receive. And can you talk about that in the context of while a decision is before a court versus before or after?
Okay, sure. So during the pendency of a divorce or paternity action where you're making an initial custody determination, obviously that does affect how a judge is going to look at who should be awarded physical custody and how much time a parent should receive for their child or with their child. It depends, I think, on when the charge happened, what the charge is, and, quite frankly, what the parent has done to remedy the situation. I have clients who come to me and say, I got charged with an OWI, or I was charged with possession of marijuana or methamphetamine. And I think that I say to them all the time, let's get you hooked up with a treatment provider. Let's get you hooked up with a therapist. I think that it's really important that you be able to demonstrate to the court, this happened, I've admitted this happened, and I've done something to correct it. Because judges really want to make sure that kids are safe. They're not there to punish and be punitive. They also understand that child, as a parent, they love that parent. I say to people all the time, you have one mom, and that is really important. Or you have one dad. You have two. If you have two parents, they need to be a part of your life. And it's really traumatic for any child to not have that connection to them. And so, again, how do we get you hooked back into it and be able to be safe with your children?